Good afternoon, everyone, and welcome to this webinar by members of Brick Court Chambers. I'm not a member of Brick Court Chambers anymore, but I'll be chairing it on everyone else's behalf. The idea of it is it's going to last about an hour, and we're going to discuss and summarise some of the legal issues that have arisen in various different sectors of work, which arise directly from COVID-19. And the format is going to be an end of term roundup, in which we're not going to go into huge amounts of detail, but we're going to give a quick summary of how COVID-19 has been treated in the cases in the various areas that we're looking at. We're going to look first at state aid, and Emma Mockford is going to help us with that. Then Alec Hayden QC and Stephen Midwinter QC will be looking at insurance and reinsurance and the issues arising from COVID in that area. Next, Sarah Abram will be discussing competition law. Then Maya Lester QC and Richard Howell will be looking at public law cases. And finally, Malcolm Birdling will be dealing with the procedural challenges that have been thrown up by COVID. Now, we're going to have about 10 minutes or so on each of these areas, and at the end, there will be, I hope, a little time for you to all ask your questions and have some of them answered. The way to do that is to email marketing@brickcourt.co.uk. And if you email your questions to that email address, I hope that it will be possible to collate them and then to select at least some of them to put to the panelists once the main presentations are finished. Great, well, with that introduction, we're going to move straight on to state aid and to Emma Mockford. Now, it's pretty obvious that the financial measures which have been taken by the government as a result of the pandemic have involved a pretty large quantities, unprecedented quantities really, of state support being given by the government to various economic actors. There's been the furlough scheme, there's been the scheme to assist self-employed workers, and there's been some support and will be some support directly to businesses. So, Emma, what approach is being taken to these kinds of measures under the state aid rules?
Well, Martin, as you say, absolutely, there's been a huge amount of state support granted by the government here and by many member states across the EU. And the Commission's response to those measures I would say, has been characterised by speed, swiftness of response and flexibility. So we saw the first state aid measure being notified to the Commission back in mid-March by the Danish government, and that was a measure to notify and to get approved support for organisers of big events who had had their events cancelled as a result of the lockdown in Denmark, and to make good the damage that had been caused to those operators. And that was the first measure we saw approved on the basis of Article 107(2)(b) of the Treaty on the Functioning of the European Union, which, as some people may know and others may need a small reminder, is aid that is designed to make good damage caused by a natural disaster or exceptional occurrence. And that is in itself a fairly restrictive basis for state aid to be granted and approved, because it normally requires a direct causal link between the aid that is being granted and the damage that has been caused to the undertaking. So it's not in some ways the most promising ground for state aid in usual scenarios and kind of business as usual terms. But that measure was approved by the Commission within 24 hours of it being notified, and was swiftly followed by the Commission itself putting out the temporary framework. What we've now seen is that it's been called the temporary framework on state aid in response to COVID-19 within another 7 days. And since that's happened...
I know that some of the people listening to this webinar will be state aid experts and probably know the answer to this question will be very obvious to them. But does the UK still have to notify the Commission of state aid, even after?
So at the moment, yes, the UK is still having to notify because of the obligations under the Withdrawal Agreement and the Withdrawal Act domestically.
Has the UK notified the Commission of any particular aid measures since the COVID pandemic struck?
Yeah, we've notified so far 3 state aid measures to the Commission for the UK, and also a further one for Gibraltar, so 4 in total. And the 3 which have been notified here have been varied. The biggest one has been the one adopted under the temporary framework itself, which I was just talking about. So the temporary framework is what's governing the Commission's main response to COVID-19 aid packages. It sets out effectively a framework for analysis that the Commission will adopt, and when its conditions are met, they will authorise the aid. And so that's what's enabling at the moment this quite swift and iterative response between Member States and the Commission, because the framework is being amended as different types of aid are notified to the Commission. So we've so far seen 3 amendments. And so the UK has so far notified 1 state aid package under the temporary framework, which is an umbrella package for state aid, which will enable all forms of aid, grants, loans, subsidies, tax advantages, to be granted to small and medium-sized undertakings in the UK, up to a maximum of €800,000 per undertaking. And that can be granted by any public authority in the UK since the umbrella scheme has been approved by the Commission. And that is a £50 billion umbrella scheme. So that's the largest scheme that's been notified. The other one that's been notified is the self-employed workers scheme that you mentioned in your introduction. And that's been notified because it constitutes aid to undertakings, because self-employed persons are engaged in economic activity themselves. But I would say that the UK's response to COVID has also been characterised by a quite robust view, if I can put it that way, of what doesn't constitute aid. So historically, we know that the UK is quite loath to notify aid to the Commission. So we've never notified as much as many other European countries. And in comparison to the 3 schemes that we've notified, if you take Germany as an example, they've so far notified, I think, 11 schemes and had them approved. And France, similarly, 10 or 11. So we're quite down on numbers front, but what we are doing is granting lots of aid that we think, and are taking the view that it doesn't require notification to the Commission because it doesn't meet the criteria. So in particular, the furlough scheme is a good example. That's state support, but it's not state aid because it's being granted to all undertakings across the economy, regardless of size, regardless of sector. And therefore it's not selective, so it doesn't meet the criteria for state aid in the first place. But nice. That kind of robustness is where we're also starting to see some of the litigation arising, because I think that robust view of what constitutes aid is itself challengeable, and that's challengeable in the domestic court. So if the member state has failed to notify, that can be challenged here. And you may be aware, and members of the audience may be, of the case being brought by CLDN in relation to the government's announcement in May of the freight support package. So we can talk about that in a bit more detail if you'd like, but conscious of time as well.
Well, can we just, we haven't got much time because we've got to rush on to the other topics that we're dealing with in this hour webinar. But very briefly, can you just touch on what you think is on the horizon in terms of challenges to state aid, and what are the constraints that are going to operate on the government in designing further economic support packages as the pandemic and its economic effects pan out?
Yeah. So I think to my mind, this area about what constitutes aid is probably the area that is most ripe for litigation. The CLND case, which I mentioned, is about the specific issue of freight routes from across the Channel Tunnel and the Irish Sea and the North Sea, in which the government has announced that it's going to give support packages to 6 operators of those routes on the basis that it needs those routes to be preserved in order to get things like food, medicines, PPE into the country, but demand for the routes has collapsed because of COVID. So normally, people would be shipping all sorts of things, and that hasn't happened because the retail sector has been closed for so long. And so the government's taking the view that the support that it's granting to those undertakings doesn't constitute aid, because in fact it's required from a public service perspective. So they're relying on the well-known case of Outmark there. And that's a decision which is being challenged. And I think we're going to see more of those challenges going forward, because I think that kind of designation where you say, well, the country needs this is a public service obligation, and therefore I'm propping up, whether it's freight, whether it's air travel, whether it's maritime travel, all of those things that I think are feasible areas. So we're going to see the government designating more public service obligations and saying this isn't aid which requires notification to the Commission, and that being challenged by competitors, which is always the most fruitful and kind of busy avenue for challenges to state aid decisions.
Great. Well, thank you very much, Emma. It sounds like it's not true to say that anything goes because there's a pandemic on. There will be some real constraints which will be imposed on government decision making in this area. So thank you for that, Emma. We're going to move on now to our next topic, which is insurance and reinsurance. And I think we're going to start now with Alec Hayden QC, who's going to speak to us about the FCA test case, which has been being heard currently in the High Court. And we're going to then go on to Stephen Midwinter, who's going to tell us about possible issues for reinsurers. But first, Alec, the test case. What is it? What's it seeking to achieve? What are the issues?
So in 2015, Practice Direction 51M implemented a financial markets test case scheme, and it's running in pilot until September 2020. The test case scheme was designed to facilitate the resolution of issues of general importance in relation to which immediately relevant, authoritative English law guidance was needed. You didn't have to have a cause of action, you just had to have two market participants who had opposing views about an issue of general public importance. Until recently, no cases have been admitted to the test case scheme, but that all changed this year when the FCA brought proceedings to resolve issues arising in relation to policies covering business interruption losses as a result of the denial of claims arising from COVID-19. As you say, the hearing's ongoing. It started last week. It's due to finish tomorrow. 8 insurers were selected and agreed to participate. The FCA is arguing on behalf of insureds generally, supported by 2 intervening groups of insureds. Insureds cover all kinds of different interests of business: restaurants, hotels, churches, service providers, all of whom were affected in different ways by the government response to the pandemic. So in these proceedings, declarations are sought on the basis of sample wordings and agreed facts, which are hoped to be of general relevance in the market. Now, standard business interruption cover insures against losses following physical damage to insured property. COVID-19 claims are being made under non-damage extensions of such cover. Broadly speaking, there are 3 types of clause under consideration: non-damage denial of access clauses, public authority clauses, those cover business interruption caused by restrictions imposed on the use of premises by public authorities following the occurrence of a disease, and then disease clauses themselves, which provide cover for business interruption following the occurrence of a disease at or within the vicinity of insured premises. None of the policy wording expressly cover pandemics.
It's right, isn't it, that this case is being heard in the divisional court? Is that right?
No, I think it's in the commercial court. It's in the financial list. It's being heard by Mr Justice Butcher, and it's of sufficient importance that they've brought in Lord Justice Flo to hear it at the same time.
Yes, that's what I meant.
Yes.
A divisional court within the commercial court.
Yes.
So 2 judges hearing a case of which is obviously going to be very significant. Now, what are the arguments that are being run about causation of loss and quantification of claims?
Well, in terms of causation, insurers are arguing that even where there's 2 aspects of causation. So there's causation within the actual insuring clause. So, for example, let's take the damage clause. Cover is provided in respect of a local occurrence of a disease, and that may be defined by reference to a prescribed radius of, say, of 25 miles or 1 mile from insured premises. The FCA argues that a pandemic has affected the whole of the UK, so there's been an occurrence of disease everywhere, and this is sufficient to satisfy what it describes as merely a qualifying condition, and that there will have been an occurrence within the prescribed radius of an insured premise. The FCA effectively contends, though, that the result of the qualifying condition being satisfied is that insurers are liable for loss caused to an insured by the disease generally, even if the local occurrence itself hasn't caused the effect on the insured's business. Now, insurers argue that the specification within the policy for there to be an occurrence within a prescribed geographic area is a key part of the definition of the insured peril, limiting the extent of cover. Cover was provided only for business interruption caused by the local occurrence of a disease. And the problem for the FCA and insureds is that no one local occurrence caused the nationwide restrictions imposed by the government or the public reaction to the pandemic or any consequent loss on those two things. That doesn't mean to say there's no cover at all. For example, if there was an insured on premises found to suffer from the disease and the premises closed as a result, that would be covered by the disease clause. And equally, a local lockdown following a local occurrence, such as the one that occurred in Leicester, that would be covered. But other than that, there are then some legal issues on causation. The relationship between the but-for test of causation and proximate cause is under consideration. Insurers argue that when you're considering causation, the counterfactual has to exclude only the insured peril, with the result that the insurers are not liable for the uninsured consequences of the pandemic. Take, for example, the case of a public authority clause, where insurers contend that in many cases the same loss would have been suffered even if no restrictions had been imposed, because of concurrent independent causes such as the public reaction to the risk of disease and government advice to stay at home. Now, the FCA counters that by relying on a case called the Silver Cloud, which I can't go into the detail of, but they assert that whether as a matter of construction or on the facts, there is a single proximate cause of the loss. And that's that there is disease everywhere, and the government and human responses to it are indivisible because they have a common underlying cause, which is the pandemic. And their counterfactual, for the purpose of establishing loss and causation, is what would have happened had there been no outbreak of COVID-19 at all. Now, insurers say the FCA is tearing up the rulebook on causation. They're converting what was specifically limited cover into very wide disease cover. Now, insurers also have the benefit of what's been discussed as the trends clause, which is also referred to as a basis of settlement clause. A trends clause expressly provides for the adjustment of losses by reference to underlying trends which would have affected the particular business or businesses of a particular type, independently of the insured peril. So they're expressly spelling out their position. But they say that just it reflects what the position would be in any event. So that's a potted 5-minute summary of what's going on currently. I can't possibly do justification to all the arguments, given the several hundred pages of submissions and 8 days of oral argument.
Goodness me. Well, thank you very much for that 5-minute summary. It makes me absolutely certain that I'm very pleased not to be having to decide that myself anyway. Stephen, we're going to come to you now on the reinsurance consequences or implications of the test case. Presumably, if the insurers were to lose the test case, they would be looking to reinsurers to stump up the bill. Do the arguments in the test case have any implications for the claims that insurers can make on their reinsurances?
Yes, they may do. I mean, the starting point is it looks as though there are going to be significant reinsurance claims, whatever happens in the test case. It seems to be the case that there are significant exposures in the London reinsurance market in relation, for example, to international contingency cover for things like the cancellation of the Olympics, other international events, and things such as Hollywood movies are going to lead to fairly large losses that are likely to impact the London reinsurance market. But the FCA test case and its implications for the volume of business interruption losses that come through is clearly going to be important. And what the test case, I think, has focused one's mind on is the nature of the insured peril. And that may have an impact on reinsurance coverage. There's going to be all sorts of reinsurance coverage issues, but one of the important ones is going to be the basis on which claims can aggregate. Because, of course, an insurer will need to be aggregating losses from individual businesses to reach its reinsurance attachment point. Generally, reinsurance is only pay if losses reach a certain high level. And so insurers are going to want to say these are all treated as one claim. And generally, in reinsurance policies, that means identifying a unifying occurrence or event or catastrophe out of which all of the claims can be said to arise. Now,
am I right in thinking, Stephen, that there was some litigation arising out of 9/11 on that question?
There was a lot of litigation and arbitration, and it resulted in some judgments which said that the attack on the Twin Towers was 2 events, and some that said that it was 1 event.
Yeah.
So it's clear that decisions in that area are going to be very fact and policy wording specific. And so what one gets from the FCA test case is that it may be important to identify exactly what is the covered peril and the basis on which it said the losses are caused by that peril. Because I think a starting point is to say that what is the catastrophe here in the UK? What is the event? And one answer to that would be to say it was the sudden rise in COVID cases across the nation in March, which led to a nationwide lockdown. That could be described as an event. But if in the test case it's decided that that's not the relevant peril, that's not what caused the losses, that you have to look at individual losses in these local vicinities within 25 miles or whatever the radius may be of the premises, if that's the basis on which coverage is granted, there may be an argument that in fact the relevant event in relation to each loss is the loss in the local area. And that may lead to problems for aggregating the losses when it comes to claiming on the reinsurance. Similarly, if the focus is on government orders, it may be necessary to treat each government order as a separate event, a separate catastrophe. And the way in which that comes out of the FCA test case may well have an impact on the way that those can be argued as between reinsurers and reinsureds.
Good. Well, thank you for that, Stephen. Just one final issue. If insurers start settling COVID claims rather than fighting them, how does that impact, or how might it impact on their ability to claim from reinsurers?
Well, that is an issue that's arising already, of course, because insurers are needing to think about their rights as against their reinsurers as they think about settling these claims that are coming in. And it's going to be important for them, firstly, to check what the follow settlements terms are, if any, in their reinsurance policies. Since the Hill and M&G case in 1996, there seems to have been a real bifurcation of follow settlements clauses. Some very generous allow insurers a very broad margin of discretion in deciding whether to settle claims. Others require insurers to prove that the losses were in fact covered by their original policy. And so insurers are going to need to take care that if, for example, they lose the test case and face a very large liability, they don't just settle all the claims without looking very carefully to make sure that each claim is properly covered, falls within the terms of their cover, and that the quantum being claimed actually represents the loss caused by the insured peril. If they act too quickly, enter into settlements without taking pretty careful steps to ensure that losses are properly covered by the insured peril, they're going to find that reinsurers say, these simply aren't covered by the reinsurance. You can't prove that coverage as against us, or you've not acted in a business-like manner, and so you've got no reinsurance coverage. And given the sums involved, that could have catastrophic consequences. Right.
Well, we'll have to add that to the list of catastrophic consequences that the pandemic has had. Thank you very much for that, Stephen. We're going to move on now, I think, to Sarah Abram, who's going to tell us a little bit about competition law and the impact of COVID on competition law. It's pretty obvious that the effects of the pandemic on the functioning of markets assumed some level of significance at the start of lockdown, and we all saw that when we couldn't find any toilet roll on the shelves, or flour, or rice, or the various other things that we were all trying to get our hands on. And now, of course, the purpose of competition law is to ensure that markets work in a liquid and fair way for consumers, both in crisis situations and in normal situations. So how how have the competition law rules been affected by the COVID crisis? Has it been necessary to suspend them or to modify them, given the circumstances?
Yes, that's right, Martin. One of the very striking effects of the crisis, kind of right off the bat, was that suddenly there were benefits to cooperation between businesses that would normally be in competition with one another. And as everyone knows, horizontal contacts between competitors about their businesses often raise something of a red flag in competition law terms. And so the legal regime had to adapt to the particular exigencies of the new situation in order to enable that cooperation to happen. And the most immediate way that was done was that at the end of March, so right at the very start of lockdown, a number of statutory instruments were laid which expressly allowed horizontal cooperation in certain sectors. The most important for practical purposes are grocery supplies and healthcare. So starting with groceries, the practical impact of the new SI was that supermarkets were able to talk to each other about things like measures to limit the number of purchases that each customer could make. You might remember that you couldn't buy any more than 3 Easter eggs a person at one point, or changing their opening hours to help vulnerable customers. And they were able to...
That would ordinarily be unlawful, would it, to have a restriction on the number of Easter eggs you can buy, or is that right?
Not if it was imposed unilaterally by a single non-dominant supermarket, but what they were able to do was to talk to each other. For instance, to say, let's all have the first hour in the morning open only for vulnerable customers, so that those people are able to go out and shop at those times, knowing that they'll be protected from, to some degree protected from the risk of infection. Or similarly, other perhaps more obvious directly commercial points, like sharing information on stock and supply chains to make sure that there was some stock in all supermarkets. In the healthcare sector, actually, it was even more marked, because usually, of course, NHS and private healthcare providers wouldn't be able to talk to each other about the services that they were offering, because that's market allocation, it's a hardcore restriction. But what they were able to do, for instance, was to have an agreement between two private hospitals, so that one might say, right, we're going to provide ward level care for COVID patients, you provide high dependency unit care, and each focus on doing their own thing. Now, look, there's a real irony to this as well, because over the last 20 years, both the grocery sector and the healthcare sector have been the subject of a great deal of negative attention for horizontal contacts between competitors for lack of price competition. But the effect of this crisis is suddenly that all that kind of horizontal cooperation is welcomed and needed.
Yeah, suddenly cooperation and coordination is a great thing, even though we've all been taught to be deeply suspicious of it. Even Apple and Google, I think, have been getting together. Is that right?
Well, yes, that's in the area of contact tracing. I mean, there are questions about the extent to which big tech companies ought to be able to cooperate. And there's a funny irony there, that they are often now the butt of competition enforcement, and in fact now we need them to be talking to each other to develop cooperative solutions. But I suppose that what that doesn't quite go so far as...
Do we need to be suspicious about their motives, or should we just accept that efforts to cooperate between entities like that are to be welcomed in the current circumstances?
Well, I'm not sure it's so much a question of suspicious or not suspicious, but I think one has to be very careful about overreach beyond what the actual core, proportionate, required competition is, cooperation is, because I think we've perhaps all seen these infringements of competition law that stem from what was initially a lawful cooperative arrangement that in a trade association or other type of body that then spills over into people talking to each other about things they shouldn't talk to each other about. And actually, the big danger perhaps is not so much the Apples and Googles of this world, who are extremely well and doubtless expensively advised. It's the smaller undertakings that may be trying to do a good thing, may not have as much in-house competition advice, and may need more, may be more at risk of things spilling over into what they shouldn't.
Okay, now that's cooperation between businesses. What about mergers?
So, interestingly, in the world of mergers, both the CMA and the European Commission both said almost immediately that this doesn't make any difference to the standards by reference to which mergers are assessed. And that's both right and wrong, because obviously the likely effect of a merger on competition is analysed by reference to what would otherwise have happened absent the merger. So the real world, what we would say the counterfactual. So it follows that inevitably the economic effects of coronavirus are going to have to be taken into account in merger reviews. And there's a really good current example of that in the Amazon Deliveroo transaction. So that involves Amazon buying quite a small stake, 16% in Deliveroo. And in its provisional phase 2 findings in April this year, so very peak of lockdown, the CMA provisionally cleared the merger on the basis of the failing firms defence, which is usually very difficult to establish. But it found that without access to significant funding, which only Amazon would be able to provide in the current climate, Deliveroo would have exited the market, and that would be bad for competition. So it cleared the merger on that basis. But fast forward 3 months, and the CMA publishes revised provisional findings. Now, it still clears the merger, but the reasoning is different because it's been able to look at real world data about the effect of the coronavirus peak and lockdown on Deliveroo's business, on the appetite for home delivery of takeaways. And it said, actually, Deliveroo's state isn't as bad as we thought it would be. It wouldn't have exited the market absent the merger. So the merger is still okay, but for different reasons. And that's a really good example of the kind of fast-moving nature of the counterfactual against which the CMA is having to work at the minute.
And just one final issue, Sarah. It looks as though that the competition rules and the factual context in which market assessments have to be made have changed quite a bit in response to the pandemic. Does competition law tell us, does competition law offer the tools that we need to be able to address harm to consumers?
Maybe the best way to think about that is to think of an example of a product which may have been affected by coronavirus and see what the tools are. So let's take, for example, the sale of gin. Now, when lockdown was first imposed, sales of alcohol for home consumption skyrocketed. And I must say, as a parent of small children who suddenly were required to be homeschooled, I can strongly relate. So if you're a gin producer, there might be various economically rational responses to that kind of demand spike. So gin producers might, although I'm sure they didn't, they might have colluded, not in the usual hotel conference room after the meeting of the Gin Trade Association, but over a Zoom video conference, very Kovid, very 2020. They might have said, let's take advantage of the increased demand by pushing up prices. Now, of course, that's easily addressed by competition law. You've got Chapter 1, the Chapter 1 prohibitions deal with that. Or you might have had a situation where one gin producer decides to go it alone, put up its own prices on its own to an excessive level. Now, we all know that's only a breach of competition law if that gin producer is actually dominant. And we can see plenty of scope for argument about whether gin's in a market of its own or whether it's in competition with whiskey or with vodka. And I think this angle really reflects the limited reach of competition law, because competition law doesn't have a sort of freestanding consumer protection remit. And the effect of that, the concrete effect, is that it doesn't have the tools necessary to protect against excessive pricing by non-dominant businesses. In most US states, for example, there are rules on price gouging, which prevents exactly that conduct by non-dominant entities. And in other countries, so France and Canada are examples, similar price gouging rules have been introduced expressly in response to the COVID crisis. CMA's asked for the same to happen here, and the government has made some warm noises, but hasn't actually taken action yet. So I think the answer to your question is that the toolbox offered by standard competition law remedies is useful, but it's not going to provide protection against every possible market disturbance.
And it sounds like, I mean, price gouging is in the current situation is probably something that would be pretty unpopular if it were ever discovered. And do you think that might be one reason why competition law rules haven't had to be resorted to, but just because companies are afraid that they will suffer massive reputational loss if they engage in it?
Do you know, I think I might respectfully disagree about that, because I think there's a lot of price gouging going on that is just outside the regulatory reach. So if you think about things like the overnight rises in price of hand sanitizer that were widely covered and that we can't do anything about unless the hand sanitizer seller in question is dominant, which is very unlikely. And so there's a degree of frustration, I think, at not being able to do anything to protect consumers, save for the CMA putting out guidance saying this is all terribly unacceptable and it must stop.
Well, that's very interesting. Thank you for that, and thank you, Sarah, for your summary of the changes in this area. We're going to move on now to public law and judicial review. And we're joined by Maya Lester QC and Richard Howell. And in fact, I think we're going to start with Richard. Richard, could you give us an overview, please, of public law cases that have related to COVID-19?
Thanks, Martin. I think it's fair to say there are two principal types of cases that have arisen as a result of the pandemic. And the first is challenges to activities which are ordinarily undertaken by public authorities, but have had to be undertaken in the rather different and changed circumstances of the pandemic. And I think the largest number of these have arisen in the immigration context. And so, for example, in the detention action case, there was a challenge to the detention of all persons facing immigration removal to countries not accepting returns as a result of the pandemic. An interim relief was perhaps unsurprisingly refused. There have been other challenges of that nature in a variety of different statutory contexts, housing, asylum support and the like, and a great number of them have been applications for interim relief. The second type of claim, and I think probably the more high profile type of claim, has been the challenges to the new measures introduced by the government as a result of the pandemic. And the most notable of these, of course, is the Dolan case. And in that case, Mr Justice Lewis refused permission to challenge what can colloquially be described as the lockdown regulations and the closure of schools and educational establishments. So that was obviously the most high profile one, given the impact that those regulations had on everyone's day-to-day life. But there have been a fair few others, and I don't sort of propose to summarise them all in the time. From a sort of legal point of view, perhaps some of the most significant, the Adiatu case, the Divisional Court dismissed a challenge to the exclusion of Limb B workers who weren't on PAYE from the furlough scheme. So those are people like Uber drivers. And related modifications to the statutory sick pay regime. It's a very long judgment addressing different grounds of challenge. And as you'll be aware, in the Christian Concern case, a divisional court of which you remember refused permission to challenge a direction by the Secretary of State, which enabled abortions to be carried out in the homes of pregnant women by the self-administration of drugs following a remote consultation. So as my very crude summary of the two types of cases has suggested, claimants haven't necessarily been having the greatest amount of success in this field.
Okay, now Maya, have there been any lessons for public law practitioners arising out of these cases about the way they've been brought, or the grounds of challenge that are likely to succeed in the current climate, or anything else really which you want to comment on in relation to the cases that have been brought since the start of the pandemic?
Absolutely. I mean, I think what is very obvious is that enormous amounts of public power have obviously been exercised very quickly in the form of regulations and guidance, which obviously has led to a field day for public lawyers and a vast number of cases that have been brought which the courts have had to deal with. And I think the court has done incredibly in difficult circumstances, which Malcolm is going to talk about, but the fact that there are so many judgments already is amazing. I think the overall point is that although Boris Johnson is very keen to curtail powers of judicial review, I think perhaps unsurprisingly, the court has been pretty clear, is my perception, about what its role is and isn't in these sort of COVID cases. So there are numerous examples in the cases decided, some of which were mentioned by Richard, about what the court's role is and what it isn't. And perhaps unsurprisingly for any public lawyer, the court has said again and again in this judgment that the court's role is not to second guess the government's really difficult choices reached in a hurry on the basis of numerous competing economic and scientific and public health considerations. They're not going to look at those political, social and economic choices. So, for example, you've got Mr Justice Lewis in Dolan saying the role of the court in judicial review is concerned with resolving questions of law. It's not responsible for making political, social or economic choices. The court is not responsible for determining how best to respond to the risks to public health posed by the emergence of a novel coronavirus crises. Those decisions and choices are one that Parliament has entrusted to ministers and other public bodies. And you have the same for Mr Justice Swift in Hussein, an interesting case about the challenge to the closure of mosques for Friday night prayers, about the importance of not questioning priorities or scientific advice. Mr Justice Swift in detention action on this being an unprecedented emergency, and therefore we've really got to cut the government some slack. And similar in Adiatu, very much on the need for a sort of precautionary stance by the government, and that being completely legitimate. So my perception is that, and I know we're going to come on to more sort of procedural matters in a minute, but my perception is that those that might get more traction with the court have been partly those that have focused on particular factual scenarios where what has happened is unfair in particular cases. So, for example, Samson Bellow's case about detention pending removal to Nigeria, where Nigeria wasn't accepting any removals because of COVID. Shane Henry's case about a prisoner on parole who had to travel between homes, which presented massively increased risks of COVID. There's the interesting case you dealt with about University College Hospital needing a bed in a hospital ward. All of these are very specific factual cases where the court is not being asked to adjudicate on these big issues of policy, but rather on the details. And I suppose the second category that might get traction, but mostly undecided yet, are the sort of hard-edged questions of law rather than we wish the government had acted otherwise. So, for example, there are really interesting cases coming up now about positive duties on the government to investigate death. So the duty to investigate and have public inquiries under Article 2 of the European Convention on Human Rights, positive duties under health and safety legislation, so the PPE challenges to the inadequate provision of PPE, information cases about the provision of information where specific statutory duties are at issue. So I'm thinking of the case about Project Cygnus saying that the government's report on the pandemic simulation in 2015 should be disclosed. So that's my sort of overall perception of the distinction in the court's role.
Right, well, there's been a hell of a lot more going on than I was aware of. Well, that's good to know. Richard, I think you were going to tell us about an interesting case involving jury trials and COVID. Is that right?
Yeah, this is the case of Mackenzie in the Crown Court at Leeds, and it was decided by a divisional court earlier this month, and it was a challenge by a prisoner to what was effectively the suspension of longer jury trials during the pandemic. And the claimant had what might be thought on the face of it quite a decent argument. And his argument was, well, Parliament in the Coronavirus Act had said absolutely nothing at all in its very detailed statutory scheme about the suspension of jury trials. And it didn't seek to address it. And similarly, the Secretary of State hadn't exercised his power to extend custody time limits for prisoners as a result of the pandemic. And so unsurprisingly, the claimant said, well, the fact that this was done in my case wasn't really acceptable. And these arguments got absolutely nowhere in the divisional court. The court accepted the Lord Chief Justice had the power by listing directions to temporarily suspend long jury trials, given the safety risks involved rather. It didn't require any parliamentary authority to do that. And the court also held that the extension of the custody time limit had been considered on an individual case, even if the general listing direction had been taken into account. And the fact it was being done so in a lot of other cases was irrelevant. And I think there are probably two points to sort of pick up from this decision. The first is what might be thought to be a somewhat indulgent attitude to potential interferences with what the Supreme Court in cases like Unison has described as the constitutional right of access to justice. And the second is, of course, the sort of broader point, which is it just didn't make any difference at all in this case that Parliament had said nothing whatever about it and the government hadn't exercised their powers. That didn't mean that someone else couldn't adopt a scheme to address the difficulties which the justice system was facing.
Right, good. Well, thank you for that, Richard. I think we're going to move on because I see the time now to talk about procedure with Malcolm. Are you there, Malcolm?
I am. Can you hear me?
Excellent. Now, Malcolm, remote hearings are obviously something that we've all had to get used to, and we've been doing them now for several months. Are we ever going to go back, do you think?
Well, I think we should take a step back and have a pause before we decide whether we go back entirely, although I doubt we will go back entirely, or the extent to which we feel that remote hearings are actually an adequate substitute for an in-person hearing in all circumstances. And that might make me sound like a bit of a traditionalist if you were being polite, or a Luddite if you weren't. But I guess as a former academic who's now a public lawyer, I'm to some extent doubly cursed when it comes to innovation, because I'll always want to make sure that decisions are being made on the basis of evidence and also that the process is being followed. So in the old days, by which I mean February, a leap towards virtual hearings in the sort of volume that we've been doing them would have been the subject of detailed proposals, consultations, pilots and monitoring. But because of the speed with which the shutters went down, the protocols we've been dealing with were all developed at speed and without really anyone having the opportunity to draw breath. That isn't to say that there hasn't been any research about whether they're actually working, and the Public Law Project and the Legal Education Foundation in particular have scrambled very quickly, and if I may say so, impressively, to investigate what has been and has not been working. And it's a sort of cheating when it comes to doing a seminar like this, but last night representatives from both spoke at the ALBA virtual annual conference and presented their research. And there were three things that I took away, which I think are quite important about deciding whether we ought to go back. And the first is, and particularly sort of apposite in discussions like the one we're having with this audience, is that we ought to be particularly wary about concluding from discussions amongst what I might unkindly call the echo chamber of judges and practitioners that things are working well. Because there's no doubt, as Maya said, that the courts have managed an impressive feat in keeping the justice system running during a global pandemic, the civil justice system at least. And I'd probably go so far as to say it was nothing short of miraculous. Speaking as someone who sat in chambers the day the Prime Minister announced the lockdown, feeling quite dispirited at the realisation that the skeleton argument I've been toiling over was probably for a hearing that would never happen. But the hearing did, 2 weeks later, go ahead. But the research director of the Legal Education Foundation said at the ALBA conference last night, and I hope I'm paraphrasing her accurately, that the exam question isn't can we keep the courts working, but rather are the new arrangements actually managing to achieve the aims of the civil justice system? And that's where I think there's quite a lot of work still to be done, because one can't leap from the fact that the courts are still managing to hear cases, that justice is actually being done in those cases, because there's a whole series of questions.
Might there be some areas, Malcolm, where we're actually doing better than we were before?
Again, I think it depends, because
can I give you an example, Malcolm? That one of the things that sometimes is quite difficult is people who want to come and see a case have got to come and physically attend court, and that might be difficult for a whole range of reasons. It might be that they've got childcare commitments and they can't get on public transport and come and see a case. But if they've got the opportunity to get the Skype link to a case and watch, dip in and dip out whilst they're doing other things, that might actually give them the opportunity to see what's going on and to observe and to participate in a way that they wouldn't have had otherwise.
I accept that, both in terms of people that are actually involved or have an interest in the hearing, and also at the public at large. I mean, I think I've never really understood the reluctance in England to televise civil hearings of interest to the public. And when the Court of Appeal had the pilot broadcasting from one court, I don't think the roof fell in. And I think that is to be commended and applauded. But I don't think that deals with all of the issues, because in order to access that hearing, you actually have to have access to technology that can do it. And if you're talking about someone participating as a party, what all of the seminars for practitioners have said is, you know, make sure you have multiple screens, make sure you have a speedy internet connection, make sure the kids aren't going to run in. And that's easier said than done if you don't have the internet at all, or one screen that isn't cracked, let alone multiple screens, or you don't have a high or perhaps any level of proficiency in English. And all of those things are necessary, I think, to access this. So while I think you're right, there will be cases where if someone does have facilities available and that will make it easier for them, embracing that technology for that purpose, I think, is a no-brainer. But leaping from that to this is a panacea to the problems of an overburdened civil justice system is, I think, an oversimplification. And I think there are probably also some courts that are better able to make that work than others, because one of the other themes that came out of the ALBA conference was that really it's a bifurcated system. There are the senior courts, and my experience is mostly in the administrative court, which I think has been functioning admirably well and has sort of worked really rather well. But the features of the hearing in the administrative court generally are you're dealing with a much limited amount of oral evidence, usually none. You're normally dealing with sort of quite constrained issues, and you're not dealing with the sort of factual, searching factual inquiries that tribunal hearings in particular quite often turn on. And the research that I was hearing last night suggested really that things aren't working nearly as well in the tribunals, and the tribunals would have a larger proportion of the cohort that I think you were talking about, people who would have difficulty accessing the courts generally. And if they're not managing to make it work now, sorry.
It's certainly true. I think certainly in my experience that there are particular difficulties for litigants in person, and we have to be very aware of the need to cater for litigants in person, because such a large proportion now of litigants are litigants in person. And you can't assume that every litigant in person has got a 200 megabit per second internet connection and perfect Wi-Fi and someone to look after the kids while they dial in, and numerous screens to see the authorities bundle and the hearing bundle and the video of the hearing at the same time.
Or indeed to prepare those bundles in accordance with what is quite prescriptive guidance from the court office.
Absolutely, although I think there's a bit more leeway for litigants in person.
That's true.
So there are definitely things that we're going to have to look at, but I think there may also be aspects that we can regard as positive, and I think it may be that we're not going to go straight back to making people travel for hundreds of miles to attend a half-hour directions hearing. I suspect the days of in-person directions hearings on or other short hearings are probably over.
The OPH list.
Shown the light.
The OPH list, when you have a represented. I mean, I guess what you could do, and what the court will have an awareness of in advance, is which cases the parties are represented in and which cases they aren't, because you'll have it in the claim form and the summary grounds. There might be a triage that the admin court office could do, and you could do away with the expense of the permission list, which, speaking as a junior public lawyer, is a waste quite often of an entire day for the ability to bob up for 15 minutes at the end of the day and say your piece. You could timetable it, and I'm sure that could be done much better. But as you know, lots of those permission cases are with unrepresented parties who do actually need to be there, I think, probably actively to participate properly in the hearing.
Now, Mark, I'm conscious I just may have deprived Maya of the opportunity to say a word or two about the procedural aspects of her topic. Is there anything you wanted to add on this point, Maya?
Hi, Martin. We were just, I guess we're sort of entering more the question and answer phase of, I was asked, what about the sort of procedural lessons for judicial review practitioners? And Malcolm's insights and yours on the remote hearings are really interesting. I suppose remote hearings plus another few things really characterize modern judicial review, and all of that has been really evident when it comes to the public law aspects of the Kovid cases. One thing that's very striking is the rise of crowdfunding in the area of public law, and that's been incredibly apparent. I mean, you can understand why people feel very strongly about the way in which the pandemic has been handled by the government, but the number of cases now that are crowdfunded is extremely high in this field. I think the other thing that's very striking, and not just Covid related, is the rise of legal blogs and Twitter in the public law sphere in particular. I mean, it's quite amazing the speed with which you get incredibly learned and helpful commentary on every new amendment to the coronavirus regulations and to all of the legal challenges on legal blogs and Twitter, and that's amazing. I suppose the only other thing I'd point to is what I think is probably a very positive aspect of the corona cases, which is the pre-action protocol for judicial review, because there's been an amazing amount, and I suppose it's thanks to government lawyers who have been, to some extent, very sensible, I think, in this field. But the number of cases that have been settled at pre-action stage on corona is quite striking. And the pre-action protocol for judicial review obviously requires people very sensibly to put their case and have it answered by the government before they decide whether to go to court. But there have been real results achieved far more, it seems to me, particularly when it comes to amending the government's guidance pre-action than in judgment so far. So, for example, families with autistic children challenged the guidance that permitted, if you remember it, outdoor exercise only once a day. That was immediately amended to cater to those with specific health conditions. Challenge to NHS guidance on those who should be admitted to hospital. Again, the government accepted it shouldn't be applied to those with some disabilities. The NHS changed its guidance on hospital visits in a number of respects. And I think it's been remarkable that there's been that degree of flexibility when it comes to particularly amending guidance, but really testament to the pre-action protocol. I think there may be another couple of questions, but
okay, well, if there are, let me just see if
I'll hand over to Emma if she is still there to answer one.
I think the question that we had for Emma is liable to open a totally new can of worms, because it was Brexit related, and I fear that if we move on to that topic, we'll be here for another hour, which
yeah,
I'm afraid we're not going to be. So I think probably on that note, we'll stop where we are. We said we would be going from 5 till 6. It's now 6. It's at least in London anyway. Lovely summer's evening. So I'm going to wish you all the best. Thank you very much for joining this webinar. I hope you found the overview and summary interesting. I hope we haven't flitted from one topic to another too quickly, but we've given you just enough to whet your appetite on the various subjects we've dealt with. If you want to hear any more on those subjects, I'm sure members of Brick Court Chambers would be very happy to hear from you. And on that note, I say to the brave, happy vacations, to the prudent, happy staycations, and to everyone, thank you very much for watching and have a great summer.